questions as my learned senior. Honorable Mwite has anything to add.
My Lords, Your Leadership, we appreciate that this Honorable Court, of its own volition, has granted leave to appeal. Speaking for myself, obviously, the decision is that of the client. So I will be advising the client, but it is for the client to make the final decision. But in fairness to me as counsel and other counsel on this bench, I will certainly be seeking to persuade my client to appeal. One issue of accusing counsel to have been talking to the gallery, that is not something that should be left on the record of this court. It is damaging to counsel, and that is an issue that definitely needs to be taken out of the record of this court by the Court of Appeal. It was a very unfair accusation. Thank you.
May it please the court, on behalf of the respondents, we thank you for the timely nature of the delivery of that ruling to allow this matter to proceed. We note that you have permitted the parties leave to appeal, and we support that. The respondents support a fair resolution of this dispute in accordance with the law, and therefore we would not oppose their right to appeal. Having said that, however, and in reference to my learned friend, Mr. Kibe Mungai, who has alluded to other petitions pending before, it is the respondent's position that we should exhaust all matters today relating to the matter that has been called out by your clerk or your legal assistant. I apologize to the lady, so that we may exhaust that, after which the court will give directions on any other matter that may be before you or may be anticipated to come before you. We thank you.
My lords, my lady, on behalf of the National Assembly, I wish to express our gratitude for the very clear ruling that the court has delivered this afternoon. The ruling has dealt conclusively, not just with the matters that were contained in the application that was hurriedly filed and responded to yesterday afternoon, but indeed some of the other peripheral issues that the petitioners unfortunately took a lot of court time yesterday to deal with. My lords, my lady, the National Assembly has filed an application dated the 18th of October 2024, and I believe that application was referred to in the ruling a few moments ago. That application, subsequent to the ruling that you have just delivered, I submit is the next issue that the court should deal with. And just to put it on record, my lord, that we are ready to proceed with that application this afternoon. Members of the court will recall that last week on Tuesday, on the 15th of this month, at an hour not very different to this, when it suited the petitioners to have their application for conservatory orders heard, they insisted on it being heard. And we request that the urgency in this matter remaining and having been noted by the court, we proceed with the hearing of that application, which has been fully responded to, immediately after this. I'm most obliged.
My Lords and Your Ladyship, further to that, for Senate, I wish to state, my Lords and Your Ladyship, that unlike the petitioners, we are willing to argue the application in a record 30 minutes.
Is this the same application?
Yes, the application dated 18th October 2024. We will only ask for 30 minutes to exhaust our application. We will dive straight into constitutional principles. We will not take much time. The respondents can have as much time as they want so that this matter can be concluded. My Lords, Mr. Kibe has talked about the gallery of Paul Mwite Senior Counsel. From that side, it was apparent that they were not just addressing the court. They were addressing other matters.
Do we need to
Let
engage?
us not go into that.
Do we need to engage in
Professor,
arguments on that?
Let us not go into that now.
I will withdraw that.
Yes.
But my Lord, we are ready to proceed. 30 minutes.
No, we don't want you to raise something and then you say you withdraw it. You know, after causing the damage,
It's okay, my Lord.
we withdraw properly.
It's okay, my Lord. My Lord, I will withdraw the remark that the petitioners are addressing the public gallery today. Most obliged.
My Lord, my Lord, with your permission, my lady, yesterday we were barred from being part of these proceedings. We have seen communication that we are now legally here. We have stopped.
Morning. Could we be allowed officially by these files being called so that we are together? We still feel that we are excluded when we are before you.
In which
Our
petition?
files-
In which petition?
There is petition 5E570,
Okay.
E550, E541, E572 that are supposed to be before you. That we complained to the CJ in the morning, and the CJ has directed we appear here and be part of this mosaic. Kindly let us be part of it.
Your Lordship, equally, I rise as the advocate appearing in E509 and associate myself with the submissions made by my learned senior counsel, Paul Mwite, and the ones made by my learned friend, Senior Kibe. Your Lordship, to the best of our knowledge, in the matter E015, when we broke yesterday, there was a promise by the court, and the court has kept that promise, that we shall be coming for a ruling of the application that was made. Yesterday I indicated to the court, Your Lordship, that this court was constituted to deal with the consolidated petitions E522 consolidated, and now E565 consolidated. And we have been issued with the notice that my learned friend Mr. Omari is referring to, that he also seized of 4 other matters: E570, E550, E541, and E572. Your Lordship, the notice that was issued to us indicated that we are coming for a mention in respect to those particular files. I hope the court is in possession of this notice, so that the court may refer to the same. Subsequent to which, Your Lordship, will be seeking your guidance on how we deal with the applications filed therein. For example, pursuant to my client's instructions, we filed an application dated the 22nd of October for the recusal of the bench. We would wish that subsequent to the court addressing and acknowledging that the other files before it, that I get directions on how to dispose of my application, for which, Your Lordship, the application was served. I wish to take directions exclusively and specifically on that particular matter.
My Lord, may please, I hate to interrupt, but this is most unprocedural. We are all counsel of some reasonable experience. We all appreciate, some of them here are very senior advocates, very senior counsel. The file before the court is the only file in which you can make an application. the court cannot make orders in files that are not before it. All these files physically brought to the court are not before court. They will be before court when they are called out by your legal assistant as being available for the court to make orders. We therefore object to this manner of conducting these proceedings. It is our very humble submission that it is yet another attempt to delay the expeditious disposal of this matter.
Your Lordship, very
My Lord,
briefly.
if I may, my Lord.
Yes.
There are matters that you have certified as urgent and that you have identified as being urgent. And I say this with a very heavy heart. My learned colleagues for the petitioners have been engaging in this dilatory tactic since yesterday. There are 2 applications before you that are certified as urgent. There are several other matters that have applications that perhaps have not been certified as urgent. Perhaps your lordships may be kind enough to deal with those urgent applications, and these matters can be dealt with later on. The files may be here, but they are not before the court.
Yeah, Your Lordship.
Okay, you have talked enough.
Counsel on this side they have.
Yes.
Counsel on that side appears to be taking the whole of it.
Because they stand much.
Please.
Just speak, Mr. Mute. If you want to be heard, just speak. We'll listen
My
to
Lord,
you.
I'm asking
Yes.
for equity of power.
We-
Accord time to counsel on this side.
They stand and speak. You also just stand and speak. We have no
Your Lordship,
stand.
my Lord.
Yes, speak.
My Lord, I think for purposes of clarity, yesterday, when we started hearing on the issue of validity of the bench, which has now been disposed by the ruling in red, the question that they wanted was the application for the validity plus the issue to do with the recusal be heard together. The understanding of the court and ourselves was that they cannot be dealt with together. So that the second preliminary issues after the issue of the validity of the bench has been disposed of are the 3 pending, are they 3? I should know about 2. 3 applications for recusal. Those are preliminary issues and they relate to the same consolidated matters that this court has given a ruling on. That is issue number 1. Issue number 2, my Lord, that is important to be noted. Yes, the consolidated file that is before you has that applications for recusal. That's what my learned colleague is emphasizing. So the second business of the court was supposed to be that one. But more importantly, my Lord, so that we do not want to hear these accusations about, oh, somebody is trying to delay this matter. We are the victim, and I reiterate that. For purposes of the petitions before you, we would like this petition heard as of yesterday. And we kept on saying yesterday, the petitions to be heard. My Lord, these rules, because it's the enforcement of the constitutions, the Mutunga rules applies. Since the Mutunga rules applies, the applications of the Mutunga rules was everybody was supposed to respond even to the petition to get the matters rolling. There have been no compliance with Mutunga rules for purposes of the respondent. So that if anybody was to be accused of any delay, it would be somebody who has not complied with the Mutunga rules. That is issue number 1. Issue number 2, my Lord, was this, that even for purposes of consolidation, the consolidated matters, some of the advocates led by my colleague, Ms. Kimoto, they were not even served with the applications that the respondents are itching to have them disposed of. So that, my Lord, because of that mess that was created as of yesterday, and the fact that we do have now a notice talking about these matters, the truth of the matter is, unless we have a situations where some of the advocates in the 4 matters that were not there yesterday have not even been served with this notice, and I know them. So that unless now we take a fresh date without somebody waiting to say that, oh, this court must discharge orders and we have a swearing in over the weekend, the truth of the matter is we need a clear date where the court ensures everybody who ought to be before you, particularly based on these issues that has been raised courtesy of correspondence with the Chief Justice, is addressed. But somebody to pretend, oh, I want to lift the conservatory order and the other side is delaying, it is unfair. We want the petition heard, and it starts with compliance with the Mutunga rules, which there is no compliance whatsoever by the respondents. So that, my Lord, I beg you that let us not appear now to be saying, oh, somebody is playing to the gallery. Nobody is playing to the gallery. We just want to assert everybody's rights. And these rights are very easy to enforce if the Mutunga rules are going to guide these proceedings. My Lord, I beg you to have the enforcement of that.
Your Lordship, I had just wanted to highlight the content of the notice which you received.
I think we'll talk about the notice. Just sit down. We want to talk about that notice.
Your Lordship,
I will talk about that notice before you speak.
My Lord, do I have your permission to address the court?
And even if the court wants to talk, you don't want the court to talk. Dr. Camino, let me address the issue of the notice.
Oh, sorry. I apologize.
Yes.
I apologize.
I think we have made it very clear in the ruling which you have just delivered that the matters before this court are very important to the people of this republic. And you will appreciate that petitions are still being filed throughout Kenya. When we retired yesterday, we received several empanelment of matters of which we gave this notice. Therefore, don't think you are the only person who are in these petitions. There are also other Kenyans who are coming day in, night out. So the matters which you've set out for mention are the matters in which we have been empaneled as from yesterday. So you wait for court to give directions, then you start talking. You cannot just start talking from the air without facts. Let us mention these files first, then from there you'll see the directions emerging, and then you can make your prayers. Let's mention these files first.
Thank you.
The other clarification is that we have two cohorts of petitions which have been consolidated. The first cohort were the petitions which were filed to challenge the processes both in Parliament, yes. And during that time, this bench consolidated 6 petitions, with the lead petition being 522 of 2024. Is that correct? That petition, number 522 of 2024, is the lead file in the petitions which were filed before the finalization of the matters in the Senate. Then, after the proceedings in the Senate, other petitions were filed. And with you running parallel petitions before the Senate proceedings and after the Senate proceedings. You will remember that petition number 522 was, we listed it for a mention on 29th of this month. But because of need to know, because I know there could be cross-cutting representation in these petitions, we decided just to call it because we knew that all of you would be here, so that if there's anything you want to say on those petitions, you can say it. So that's the reason why we have petition 522 here for a mention. There's nothing to be mentioned, but we said since parties are likely to be here, and some of the parties were even asking for it yesterday, so we brought it. But the other petitions to be mentioned are specific petitions where we have been empaneled. And we wanted to find out the way forward, whether we can consolidate these petitions or whether they can be done separately. So these are petitions number let's mention petition number 570 of 2024, A.D. Waiguru and Victor Gatia. Yes, this petition.
Yes. My Lord,
Excuse me. Just a minute. Yes.
My Lord, in this petition, this one was filed by the law firm of, I believe, Mutembei and Maret, it's called what? Mutembei, Geshoro and Company Advocates. I am aware of this petition for the simple reason that he had requested me that when it comes to the hearing, I appear alongside him.
Alongside who?
Mr. Mutembei Marete. My Lord, the parties are many, starting with the first respondent, I think is President Ruto. Regarding Gachagua is the second respondent, and there are others. My Lord, for purposes of this petition, it was filed after the. For purposes of this petition, it was filed after on Friday, and by Judge Mamuye, referred it to the Honorable the Chief Justice, and we expected it to be coming tomorrow on Thursday. My Lord, Mr. Mutembei was not served with this particular notice that is before you.
Actually, nobody was served. We sent out the notice in the morning today because
Yes.
we received them in the morning.
In the morning.
And that's why I said that this matter is coming.
Yes.
And because the representation is likely to be across, we
Yes.
mentioned them because we thought we'd find people like you waiting
Yes,
for them here.
Waiting for them here.
Yes.
So that, my Lord, in that case, what I would ask the court, and for the additional reason that I am aware that in that matter, the notice of motion is seeking a 5-judge bench, and particularly for the reason that this is an application by the citizens of Central Kenya who says, like in the year 2013, that their rights, not just regarding Gachagua, have been affected adversely by the impeachment of the Deputy President Gachagua, and therefore I would ask that this matter do come tomorrow so that the issue on that issues of empanelment and in the presence of Mr. Mutembei can be dealt with. Because now that it is obvious that even the direct, like the advocates who filed the case are not here, it would only be fair that there is another mention where they can also be there. Actually, we didn't even have the file. We are just looking at it from our record. But that is the position as far as 570 is concerned. There is a specific application for a 5-judge bench in that matter.
Mr. Kibe.
Yes, my Lord.
We are beyond that. There was a request for a 5-judge bench,
Yes, my Lord.
but what has been empaneled is a 3-judge bench comprising Justice Eric Ogola, Justice Mrima, and Honorable Dr. Justice Freda Mugambi. So the request for a 5-judge bench, I think, is overtaken by events unless he wants to appeal.
Yes. The chances of appeal are very high. For the simple reasons, my lord, that will become apparent. I believe there must be some mechanical applications to the issues, but now that it arises specifically, that issue would be addressed, and the Chief Justice would have the relevant communications tomorrow morning, while given the nature of the issue that must be dealt with, there must be a 5-judge matter. All benches can be expanded. I believe that is the positions that we are coming from. So without saying specifically that we don't want anyone, all benches are capable of being expansion, particularly bearing in mind, and this is something that a number of the clients that already we are representing, there have been repeated insinuations by our people out there, including Senior Counsel Abel Nasir Abdullahi, that the senior bench is supposed, the 3-judge bench is supposed to do this or the other. We can't help that. This is not coming from the petition.
What we'll do, Mr. Mugai, is that we'll mention this matter tomorrow.
I'll appreciate. What time, my lord?
At 9.
Most obliged.
Mr. Kibe, you will serve.
Most of the people actually here, we had served them, but we shall serve the notice of hearing.
All right.
The notice of hearing for the mention tomorrow at 9. I thought, my lord, the 10 would have been easier, because by the time I go to my office, there will be nobody to do some of these things. Or probably 11.
You know, but the time we spend here means that even if you come at 10, you'll find us here.
My lord, what time then do we come tomorrow?
The court starts at 9.
Yes.
You can come at 11.
11. What's
Yes.
obliged?
My lord, I am asking, please, in this particular file, that you record my presence together with the other lawyers I mentioned earlier as appearing for the deputy president with the second respondent.
This one?
Yes.
The verified?
Yes.
But you didn't stand up, Mr. Mute. I thought you were not here.
Patiently wait.
This matter of 570?
Yes. If you look at the party, the deputy president is the second respondent.
So you agree with the directions which you have given? Eh?
I accept directions of the law. And I will be here tomorrow at 11. Inshallah.
Please, Your Lordship, in this particular matter...
Let's the same matter?
Yes.
570?
Yes, my name is Manzo. I'd wish to go on record for the first interested party.
Your Lordship, my lady, may I be placed on record for the second and the fourth interested party? And permit me to only indicate the implication of the orders of the imparlment that were issued by the judge who directed the Chief Justice does impanel you. To the best of my thinking and knowledge is that the prayer was granted as it is for the imparlment of 5-judge bench.
Mr. Jerry. Jeru, yes.
They want Jeru.
We speak from the record. You heard me mention the parties. I said that this file has been empaneled to comprise the Honorable Mr. Justice Eric Ogola, the Honorable Mr. Justice Murima, the Honorable Dr. Judge Freda Mugambi. I think that's very clear. We are only 3.
That's correct. But okay, I will address you tomorrow on that issue.
My lords, my lady,
So we mentioned it tomorrow. Mr. Njiru, you say you come for which parties?
Your Lordship, I appear for the second and the fourth interested party.
Thank you.
My Lord, perhaps if I may make a request. My Lord, there is a file that is live before you, and that is petition number 565 of 2024. We have requested, my Lord, that you give directions in respect of the applications in that matter, because this process of taking quorum might take some time. And there are 3 cohorts of files that are before you. And if I may just be given a moment to explain myself. As the court has correctly identified, there is a cohort of files that are consolidated in petition 522. There is a cohort of files that is consolidated around petition 565, which have the 2 applications that the court has identified as urgent. And then there are these others that have been referred to the court by virtue of the email that we have all seen today. It is my request that the court keeps them in those cohorts so that the applications are able to be dealt with because they are urgent. These are important, but the applications are urgent. And the court has identified that urgency because this will go on for 2 or 3 hours without any directions having been given in 565.
Lord, could we be on board together? We are being made orphans. The state is in the bedroom. Let us also be in the bedroom so that we can respond.
Mr. Amar, what do you want to do in the bedroom?
We will discuss. Can we allow the parties?
Mr. Nyamodi, the reason why we are mentioning these matters is to find out if any of them would be ripe for consolidation with the matter which is here so that we don't duplicate.
Thank you, my Lord.
My Lord, perhaps as you consider that, let me put it on record that if you are considering whether they are ripe for consolidation, the consolidation should not then slow down the hearing of the application that you have already identified as urgent. If they are to come on board, they come on board and proceed from where we are.
Let us be on board first. We respond to him appropriately. Allow us, even the escape from our
Give me the next.
Be on record.
My lady and my lords, I just have a passionate plea to make. There are not many pleas. The first plea is this: could we consider utilizing the ceremonial court on the ground floor because it is spacious and sufficient to hold all of us? That's number one. Number two, my request is this: the court has all the petitions. Why can't the assistants to the court enumerate the parties there in the quorum in the manner we used to do in the Court of Appeal before, so that when we appear here at whatever time you'll indicate, we'll just fill our respective names and the courts will be able to deal with the matter without the need of this back and forth. Number three, my lords and my lady, I think the court needs to just be a little bit proactive. When you retreat, you may make 2 decisions. One, either to determine the interlocutory applications, in which case you can frame issues for the parties to submit on. Or 2, if you're minded to hear the petitions themselves, then still frame the issues and forward it to us so that we're able to make progress. That way we'll make good use of the judicial time that is very limited in respect of this matter. I beseech you most sincerely.
Thank you, Mr. Harvey. Well taken.
As a former chairman of the House of Science, let me second the first issue and plead that if only for the purposes of everybody getting sufficient oxygen, because we are too crowded and the people want to listen, and the media and the members of the public, if it is possible, let us use the ceremonial hall.
Council, Senior Council, we will use the ceremonial hall as from tomorrow.
Thank you.
And
I wish to say that perhaps when giving directions, then and if parties, I mean files are going to be consolidated, then it would be proper each person is served with the application so that we are able to respond, even if we are given a day to respond, so that when we begin to submit, we are able to submit according to the law, not as per the bar and whatever issues are being raised. Thank you.
Thank you.
My Lord, I was going to beseech the court, if we are to make progress, I will beseech the court to invoke its powers under Section 5, Article 159. We will go on and on. There is no shortage of legal provisions enabling this court to rein in on the lawyers. Because if you don't do that, my Lord, on a matter like this where you are 20 lawyers, 50 lawyers on the other side, we will be coming to you. We'll be doing legal gymnastics, legal ping pong, what I call legal sophistry on other occasions. And meanwhile, we'll be lamenting, as we are now lamenting to you, that there are applications, both from this side and this side, certified agent. Meanwhile, we are spending a lot of time, each of us from whatever side, studying to raise this or other housekeeping issue. I beseech you, my Lord, in a matter like this, the court must be very firm. It must run the council. The court itself must have very clear direction. Which is the application that will be had, in what sequence, what are the time allocations, how the parties share those times.
We have agreed on that, and what we ask is let us mention these matters so that we know how they relate to the other matters which are before the court. So we have mentioned 570. We have mentioned, do you have 570? We have mentioned 570. There's, which one did we mention? This 550. 550. We have mentioned E570. E550, Speaker of the National Assembly versus regarding Gachagua.
My Lord, this file is already consolidated under the cohort of 522.
$550.
When was the petition filed?
No, I'm sorry, my Lord. That was not consolidated.
Yes. 550. Who is in 550? Who is in 550?
My Lord, mine is 572.
I'm asking 550.
Yes, my Lord, in 550. Milimu, my Lord, with Ole Kuyoni. We appear for the first respondent.
I guess you can tell us who is the petition.
The petitioner, my Lord, is the former Deputy President, my Lord, represented by my Lord Senior.
My Lord, I appear for the Deputy President, not former. He remains in office on the basis of the conservatory orders, and each bench has confirmed weighty issues, which is why we are here. Let's not join the rush.
For the first petition, huh?
For the first petition. I thank you.
My Lord, if it pleases you, Nyamodi and Gumbo for the second respondent. And our learned colleague, Mr. Murugara.
Is this my husband?
I appear together with Thank and my senior professor of GMW for the third and fourth response.
Yes.
Who else is in this matter? So, for the petitioner, Mr. What are the issues in this matter? Are they relevant to the consolidated petitions?
The petition has that.
There are so many files. Yes.
This is
the same team of lawyers,
yes,
including myself that I gave when we came for the ruling,
yes,
is appearing for the deputy president.
But what I'm asking is,
yes,
is it going to be consolidated or is it standalone?
It's not one of the ones that we are consolidated. I believe.
No. But Lord, sorry if I appear repetitive.
Yes, speak, please.
For you to be able to progress, I beseech you, you adjourn this matters to tomorrow. Go and make directions. You're either hearing the petitions or the applications. Come here so that we have a perspective upon which to progress. Otherwise, we will not make progress.
We are unaware of that fact, Mr. Harvey, but you know,
it's my advice.
You know, it is the councils who will be saying that their right to be heard, yes, even on petition, even if the slightest issue has not been granted. Therefore, let us agree on the way forward. If you make a proposal can come from you, your side, how you want to deal with all these petitions. Is it possible that you want to ignore all applications and proceed to the petitions? You can make, yes, a submission which this court can consider.
My Lord, if I may, just to guide the court, and on this account I will do it as senior counsel. My Lord, there are urgent applications before you. The applicants or the petitioners had their bite yesterday on a preliminary objection that the court has ruled on this afternoon. My Lord, we have an urgent application that was filed before you, dated 18th October 2024, for discharge of the conservatory orders. Whatever decision this court makes, it can be either way, will lead to directions on the hearing of all the consolidated petitions. Some of the petitions, my Lord, deal with issues or causes of action that arose before, my lords, the impeachment. The proper position of the law is that the party who is the petitioner is the former deputy president. That's the position of Article 145(7). Allow us, my lords, to urge our application for the setting aside of conservatory orders. I think, my lord, that's the only way we can move, because they have had their bite, let us have our bite as well. We will only take 30 minutes, we request.
I'm not disagreeing with you, Professor Jenda. What I'm saying is that let's mention these files. We are on the third one, and if you have not been interrupting, perhaps we'll be through with them. 550, I've recorded the quorum. And what I asked, is this file related to the files before the court? For the purposes of consolidation, or it can stand alone?
Can we deal with that? Why not?
Because there is a...
Consolidation has implications. I need to consult my team. I need to consult the client. Let's take the quorum. Let's deal with consolidation.
So we'll mention it tomorrow.
Yes.
Next. 541, Dr. Clarence Oboso. Dr. Clarence Oboso.
And I am the second petitioner in the matter. The first petitioner, Dr. Clarence Oboso, is online, my lord. My lady, my lady. And I believe it's one
May it please the court. My name is Dr. Clarence Oboso. I'm the first petitioner in E541. The petitioner is between Dr. Clarence Oboso, Ms. Wanjiru Mwangi, versus the Speaker of the National Assembly, the Attorney General, and with the Law Society of Kenya as an interested party. The petition relates to the process of impeachment, particularly in the National Assembly, and seeks orders to quash the proceedings in the National Assembly. The petition has an application which was certified urgent and which sought an injunction against the entire proceedings of impeachment. The court which certified it urgent directed that the application would be heard by the bench that would be constituted. Several of the prayers that were made in the application have since been overtaken by events. However, the substance of the application sought to conserve the issues as they were, and therefore the conservatory orders that were issued by the court in last week on Friday protected some of the prayers that we had made in the application. Yesterday I pointed out to the court that proceeding with the discussions on the conservatory orders would have prejudiced us because then we would have lost out without participating.
Honestly, Judge.
Our prayer would be.
No. We need to make progress.
He's arguing the application. We are taking so long.
Just tell us, Mr. Clarence, whether this petition, you want it to stand alone or whether you want it to be consolidated with the petitions for the court.
That's where I was going to go.
Just go there, please.
I will be seeking that the petition be consolidated with the petitions relating to both the impeachment process and the filling of the vacancy that arises from impeachment. The reason being, upon filling of any vacancy.
Okay, we have heard you. You are agreeable to this petition being consolidated with the petitions which are in file number 565 of 2024.
My Lord, may I just conclude? My Lord, may I just conclude that I will be willing to compromise our application provided that we can be allowed to participate in the applications for conservatory orders that are before the court.
My Lord,
they need the time.
With your permission, my lord, I appear for the first respondent in the matter. Yes, and my lord, I note that we didn't come with our file.
Is this petition post-Senate proceedings?
No, my lord. It has no relation with the post-Senate. It was filed, my lord.
Before?
Before. And it does not touch on issues, my lord, that happened at the Senate. Ordinarily, my lord, will be opposed.
So we mentioned this matter?
Tomorrow, my lord.
We mentioned this matter on 29th when the petition number 522 will be mentioned.
Most obliged,
My lord, tomorrow or on the 29th?
My lord.
Yes?
I'm not sure if the court got the last statement I made. It would be greatly prejudicial to us if the discussions relating to the conservatory orders continue without our participation, because we are essentially raising the same issue in our application.
My lord, I agree. As we filed our application on the 8th of October 2024, before the National Assembly had even made its impeachment, had impeached Deputy Brigadier Gachagua, my lord. We are acting in person, we are laymen, my lord, and we are also protected by the same laws, Article 27, Article 47, 48, and 49, and 50, my lord, for the right to a fair hearing. So we do ask the court does mention our matter tomorrow, so that we can articulate the points that we need to.
My lord, I appreciate the fact that the petitioners are appearing in person. My lord, once the court has made an order, my lord, the only remedy available to the parties is either to appeal, my lord.
We have not made any order. You know, we talk before we make orders.
Sorry, my lord.
So we'll mention this matter tomorrow.
It will be available, my lord.
572? 572?
Yes. My lord, the presiding judge, my lord, and my lady, doctor, if it pleases you in the matter. My name is Wamboi, Shadrach Wamboi. I have the honor and privilege of introducing counsels for the petitioner. I appear alongside my learned senior, Mr. Dunstan Amari.
I'm present.
Mr. Samson Nyaberi, my senior.
I'm present.
My learned colleague, Mr. Nicholas Karanja.
I am present.
And my learned colleague, Miss Melissa Omeda. We all appear for the petition applicant. Thank you.
My lord, in that matter, I am Shadrach Mose, the Solicitor General, appearing for the Attorney General, together with Professor Gitu Muigai, Senior Counsel, Emmanuel Peter, Deputy Chief State Counsel, Charles Mutinda, Deputy Chief State Counsel. Much obliged, my lord.
Thank you. My lord, if it may please in the matter, Milimo, my lord, I appear alongside Ole Kuyoni for the first respondent.
May it please you, my lord. For the second respondent, my name is Gumbo. I appear together with my learned senior colleague, Mr. Paul Nyamodi, and Mr. Honorable Gitonga Murugara.
Very pleased, my lord, my lady. That matter, my name is Edwin Kelly. My lord, I appear together with the senior professor of gender. My lord, Senator Hilary Sigay, and Miss Mercy Tanji. For the third respondent, my lord, Miss Dr. Bismarck.
For the third respondent.
For the third respondent.
The Deputy President is the interested party, and I appear with my colleagues, Mr. Ngoya, Mr. Macharia, Jomo, Degwa, Sakimpa, Wandati, Victor Swanya, Faith Muge, Faith Waigu, and Mr. Muge.
And Mr.
Muge. For the interested party, that is the Deputy President.
Thank you, my lord. My lord, just to respond to the question whether this petition should be consolidated with the others, the questions that have been posed in the instant petition question the constitutionality of the impeachment process at the Senate that led to the removal by way of impeachment of the Deputy President. Secondly, my lord, it also questions the constitutionality of the appointment of Professor Kithure Kindiki as the Deputy President designate in that office. And for that reason, my lord, the view that we take with humility is that the petition is ripe for consolidation. And my lord, just for the avoidance of any doubt, and my lady, we have an application filed and dated the 18th day of October 2024 that sought an order of conservatory order to stop the implementation of the decision made by the Honorable Speaker of the Senate, Honorable Amason King. So, my lord, when we canvass or we are to canvass the applications as to whether the current conservatory order should be disturbed or not, we want to actively, and we seek with humility, to participate in those proceedings. Thank you.
The parties, are you opposing the possible consolidation?
Yes, my lord. We are vehemently opposed, my lord, to the joinder or intended consolidation of this petition. And my lord, so that we don't take time before you this evening, we would prefer, my lord, that this matter also takes the cue of being mentioned tomorrow with the others, my lord, where we will substantively, my lord, be presenting, my lord, before you reasons why this matter should not be consolidated with the one that is before you today. And my lord, so that we save time, I speak for all the respondents.
Mention
unless the
tomorrow.
Attorney General. Sorry, my lord.
Mention tomorrow.
We mention tomorrow, my lord.
My lord, if you permit me. My lord, there is a mischief that we need to cure or to safeguard ourselves against. My lord, there is an attempt to have a litigation by way of installment in this matter. So much so that, my lord, if you look or you find time to look at the petition and the application, you will see that the issues that are raised by my seniors and counsels for the petitioner are synonymous, they are the same.
Since it is not consented to, why don't we listen to it tomorrow?
Most obliged, my lord, because the question of consolidation is a question of law, and it's purely on a principle question. And my lord, we will be ready to argue the question of consolidation as and when we are invited. Thank you. Yes, please. And my lord, and my lady. Yes, I am guided by my senior counsel, Paul Muite. The question of consolidation is one that even the bench, as it is currently constituted, can actually look at the matters and on its own motion, suo motu, give directions or orders, whether it is deserving to be heard alongside the other matters, or we just need to take a cue behind other petitions.
My lord, the court has spoken. You mentioned it tomorrow. Thank you.
Let's consider that tomorrow.
Most obliged, thank you.
572. 522. 522. This file has a mention date for 29th of October, but because issues are arising, we wanted to mention it again today if there is any issue arising out of it.
In terms of appearances, and in order to save the court's time, the same counsel that I enumerate are appearing for the petition, the Deputy President, in this matter.
Yes.
Yes, my lord, for the respondents, the quorum is similar, my lord, so that we save on time. My lord, we will be willing, my lord, to present before court two options. Either, my lord, we retain the mentioned date that had been given, or, my lord, you mention the matter tomorrow, so that if there is any party who would want to address you, would address you tomorrow, my lord.
We don't want back tomorrow with so many matters. If there's no need, we can retain the 29th.
We can retain the 29th, my lord.
Okay, we can mention it tomorrow. Let's mention the matter tomorrow. So we are clear with the mentions. We can go back to petition number 565.
No, you have not mentioned my matter.
Which one?
509.
509. It was consolidated with 5.
Sorry, I'm sorry, I never heard you call it out. I'm sorry, Mr. Kip was keeping me busy giving me. My lord, in that respect, we have an application. The Lordship, I hope it's on record. We could also mention and get directions tomorrow on my application for the recusal of the bench dated the 22nd. I would be most obliged, Lordship.
We are mentioning the matter tomorrow.
Most obliged.
So then we are back to the petition number 565.
We wish to confirm that on the part of the Attorney General of the Republic, we are ready to argue our application certified urgent by this court or by the court referring the matter to this court.
My Lord, I believe this is the matter that we had earlier indicated, that after all these matters have been consolidated, directions have been given on these matters, specific directions need to be given for purposes of that matter. And for purposes of enabling those specific directions to be given, I want to point out three things. Number one is that we would need directions on when the first application that was to be done after the validity application is determined, when we are going to be heard. That is issue number one. Issue number two, my Lord, that is important, is the fact that now that today the Honorable, the Chief Justice has caused all of us to come on the basis of these other matters, the point needs to be noted that for purposes of the basis for all these matters that empanelment was done, the reason was that there were applications for conservatory orders. Those applications for conservatory orders were first certified as urgent and would be the first business of this court appearing there, assuming there is no other preliminary issue like recusal or other ones. Thirdly, my Lord, is this, that for purposes of those applications where conservatory orders were made, the conservatory orders may have been made in 2 or 3 files, but they conserve the status, status quo that is cross-cutting in all the petitions that are before you. Apart from the fact that in that particular petition, the one that has conservatory orders, when this court, because all those applications were done on Saturday, the parties, starting at least with those that I represent, because of the nature of the proceedings that were there yesterday, we have not completed doing the responses to the applications by the Attorney General to lift conservatory orders. We could not be able to do the authorities for reasons that were indicated. And more importantly, my learned colleague, Mrs. Kemodo, whose file has been consolidated, did indicate she has not even been served, and in that matter, she needs to respond and be heard. Therefore, my Lord, in considering these issues that is itching the group that wants lifting of the orders, I would like the court to give directions bearing in mind that the stakes of the parties, all the people who have filed petitions, is to ensure you are not faced with a fait accompli, where you are told, we have already sworn Kindiki and you can go to hell. We do not want to be faced with a fait accompli situations. My Lord, it would be absolutely important that the subject matter is preserved, if not for any other day, until all the parties are before the court. Your Lordship. Your Lordship. There is
you can see that we are consulting.
Proceed in these matters as follows. By tomorrow, we will issue comprehensive directions on various issues. But importantly, parties are already aware that there are two cohorts of matters. The first cohort involves the petitions which were filed challenging the happenings before the National Assembly. Those petitions will proceed as cohort 1. They are the subsequent petitions which were filed challenging what transpired in the Senate. That is cohort 2. By tomorrow, we will deal with the issue of consolidation. We are aware of the powers this court has on the issue of consolidation, just like how we exercised the powers yesterday. We may decide to either hear or give directions on the consolidation. However, we are in agreement that the next application in line can only be one, and it is the application for recusal of this bench. And that is the application which, after we do everything, tomorrow at 2:30 is up for hearing. If you intend to participate in that application, in the second cohort, that application is coming up for hearing tomorrow at 2:30. In the morning, we will deal with the issue of consolidation. That one we will give directions on that. So that is the way forward. Prepare to hear the application for recusal of the bench tomorrow at 2 p.m. In the morning, we will deal with the procedural issues of consolidation and any other issue which may arise in cohort 1 and cohort 2. Thank you.
And yes, very clear directions about your leadership, and we entirely agree that we will assist in the orderly progression of the hearing of this matter.
My Lord, perhaps my Lord, we assume it is all the 3 applications for recusal. So
there will be no other application for recusal. We will hear what is on record, and it will be a ruling will be delivered. There will be no other application for recusal. And we think that that should come first, because if you don't want the bench, there's no reason why we should do any other thing.
My Lord, I was only pointing there are 2 or 3 of them.
Yes.
And the only clarity I'm asking is whether all applications for recusal will be done together.
Yes, together. All will be handled together.
Your Lordship, finally, as you categorize these pleadings in cohort 1 and cohort 2, kindly allow me to remind the court that the last time we were before you on the 16th, the court gave or granted leave for parties to amend their petitions. So there could be petitions that have now crossed over to cohort 2, pursuant to the amendments bring in light what transpired. Perhaps the pleadings will bear witness.
Mr. Ndegwa, those are some of the preliminary issues which we'll deal with in the morning. But principally, prepare to argue your application for recusal at 2:30.
I am ready.
My Lord,
even
before we break, and with your very kind permission and indulgence, I would like to put the deponents of the affidavits that have made very, very grave allegations about judges of this court to be present tomorrow at 2:30, because we reserve the right to cross-examine those deponents and to move the court as appropriate after that.
Yes. My Lord, perhaps if I may request that the court supplies us with a typed copy of the ruling that you have delivered today. We know you are working under very tight timelines, but we would very much appreciate a typed copy of the ruling that you have delivered today. We believe it may be useful in the tasks at hand tomorrow.
Finally, Your Lordship, this is the ruling that you delivered on 16th of October in the Consolidated Petition 522. Thank you, maybe you can get a copy of that ruling as well.
The ruling should be available. So,
yes. Finally, my judges, I think there is an hullabaloo about service, that there are some parties who are present and have not been served, and we've been hearing this from inception. I think tomorrow we settle the issue of service. We also settle the issue of filing of any affidavits or responses that ought to be done, so that after 2:30 we know how best you're going to proceed without people intervening with, I have not had sufficient time to do this or that.
And I think before my presiding judge addresses, I just want to remind parties that we are using technology to move. To me, the issue of service should not be a big thing, because if you are mapped into a matter, automatically you get everything, unless you are not in the system. And if you are not in the system, get in touch with the deputy registrar. As simple as that. So that we avoid these issues of, I was not served, I was served, I was not served. Let us make use of the technology at hand. Thank you.
May I suggest that, Lord, we are appearing tomorrow in the ceremonial hall at 11. I was going to plead that any other issues being raised from the bar be raised tomorrow at 11.
My Lord, as the chair in charge of all the people who are retiring, I ask that we adjourn at this particular moment so that all people can go and rest.
Just to avoid any doubt, the application for recusal will be heard at 2:30. Whether you have responded to it or not, we will hear it. We will not allow any adjournment on it.
And what time tomorrow morning, sir? Because some of us didn't get the exact
Tomorrow
time.
morning at 9.
At 9, yes.
Yes.
And we're being told 11. See, it's at 9 o'clock.
For clarification purposes, is it physical or you can do virtual both?
So I think that concludes our sitting today. That concludes our sitting today. See you tomorrow.